Hello, esteemed viewers. My name is Foluso Oyekale, a 400 level law student of Ayo Babalola University and an undergraduate intern at HARLEM Solicitors. Today, I'll be giving a lecture as to the technical specification and regulatory stipulation for the installation of a base transceiver station. First of all, what is a base transceiver station? A base transceiver station can be said to be a telecommunication infrastructure that facilitates wireless communication between a subscriber's device and a telecommunication service operator. A base transceiver station is otherwise known as a BTS site or a telecommunication mast or tower. The Nigerian Communication Act of the year 2003, hereinafter referred to as the 2003 NCA Act, is the legislative body concerned with telecommunication matters in Nigeria, and pursuant to Section 3 of the NCA 2003, it created and established the Nigerian Communication Commission in order to make the Nigerian Communication Commission. Section 70 of the NCA 2003 confers power on the established commission to make guidelines, laws, rules in order to regulate telecommunication matters in Nigeria, that is to drive home the objective and achieve the goal of the Nigerian Communication Act. Section 135 of the NCA 2003 states that permission and approval must be sought from respective body for the laying, cabling, maintenance, and installation of network facilities. In this situation, a telecommunication mast or tower. Like I said earlier, power was conferred on the commission in order to make guidelines for telecommunication regulation in Nigeria. One of the guidelines they made was the guidelines on technical specification for the installation of mast or tower 2009, hereinafter referred to as the NCC 2009 guidelines. Paragraph 1 sub 1 of the NCC 2009 guidelines states that the Act shall establish standards to be adhered to by telecommunication operators before the installation of a telecommunication mast or tower in Nigeria. Paragraph 1 sub 5 states that non-compliance with the provision of these guidelines will be deemed a criminal offense punishable under Nigerian Communication Act 2003, Nigerian Communication Enforcement Process Regulation 2005, and other applicable laws. Paragraph 3 sub 5 states that for the installation of a telecommunication mast or tower to be in residential area, the height must not exceed 25 meters. But as we all know, where there's a principle of law, there is always an exception. Pursuant to paragraph 3 sub 5 of the NCC 2009 guidelines, it states the exception to paragraph 3 sub 4, and it states that two conditions must be fulfilled before the installation of a telecommunication mast or tower in residential area, and it goes thus. The one, there must be prior approval sought from the commission, that is the Nigerian Communication Commission, and two, there must be a perimeter setback of 5 meters from the telecommunication mast or towers to the nearest demised property. Paragraph 7 sub 1 sub A states that irrespective of the height of a telecommunication mast or tower in Nigeria, it must not be installed within 15 meters of an airport or within proximity of helicopter bars without prior approval from the Nigeria Airspace Management Authority (NAMA). Paragraph 7 also states that where a telecommunication mast or tower is to exceed 30 meters in height, prior approval must have been sought or a certificate of clearance sought from the Nigeria Airspace Management Authority (NAMA). Paragraph 9 sub 1 sub A states that the maximum height of a telecommunication mast or tower in Nigeria is 150 meters. But like I said earlier, where there's a principle or rule of law, there is always an exception. And the same paragraph 9 states that where a telecommunication mast is to exceed 150 meters in height, 4 conditions must be fulfilled. 1, it must not be detrimental to public health, public safety, and general welfare. 2, it must not impact negative effect on the community. 3, it must not impair compliance with regulatory telecommunication laws. And 4, it must go in conformity with the future plan of the area or the future plan of the community. Paragraph 9 sub 13 states that where two telecommunication mast or tower exceed 55 meters in height, there must be a distance of 1 kilometer between the two of them. And at this point, it is pertinent to note that paragraph 3 sub 6 states that non-compliance with these stated guidelines will lead to the removal of the telecommunication masts and towers, whose cost in which the cost of the removal will be borne by the owner of the telecommunication mast or towers. However, although I said that NCC, the legislative body, is concerned with regulatory telecommunication matters in Nigeria. The National Environmental Standard and Regulation Enforcement Agency, NESRA, established in the year 2007, also created a regulation as regards telecommunication in Nigeria. And the regulation is known as the National Environmental Standard for Telecommunication and Broadcast Facility 2011, hereinafter referred to as the 2011 regulations. But this does not confer on NESRA the sole or the jurisdiction over telecommunication matters in Nigeria. Paragraph Regulation 5 sub 3 of the 2011 NESRA regulation is similar to paragraph 9 of the NCC guidelines, and it states that before the installation of a telecommunication mast and tower, it must be deemed that 1, it is not detrimental to environment, public health, it must not impair compliance with any relevant law, it must be in conformity with the future plan, it must have an environmental impact signage, and so many other requirements. Regulation 5 sub 4 states that there must be a setback of 10 meters from the installed telecommunication mast and towers to the nearest demised property. But this is a contradiction with the NCC guidelines that stated for 5 meters. But this is a contradiction of federal rules. Therefore, it led to a tussle between the two ministries, the Ministry of Environment and Urban Development and the Ministry of Communication and Digital Economy in Efad Estate, whereby NESRA, the National Environment Standard and Regulation Enforcement Agency, held that MTN did not comply with the stated perimeter setback of 10 meters, and NCC on the other hand held that they complied with their perimeter setback of 5 meters after so many to and fro arguments between the two resolutions. On the 4th of June 2014, a resolution was met between the two ministries where they held that where a 10-meter setback is impossible, a 7.5 meter is allowed. And also, any installation of telecommunication mast or tower that predates the regulation of NESRA will be referred back to NCC for remediation. Alongside the installation of telecommunication masts and towers in Nigeria, it is pertinent to note that they must also comply with the permissible noise level. The mode of measuring a noise level in Nigeria is decibel. Measuring a noise level is decibel. In residential areas, it must be 50 decibel by day and 35 decibel by night. In commercial areas or industrial areas, it must be 55 decibel by day and 45 decibel by night. In homes of the aged, schools, hospitals, it must be 45 decibel by day and 35 decibel by night. By day in this context means from 6 a.m. to 10 p.m, while by night in this context means from 10 p.m. back to 6 a.m. I hope that with this my view, I have been able to elucidate the technical specification and regulatory stipulation for the installation of telecommunication masts and towers in Nigeria. For further inquiry on telecommunication matters, kindly visit our website at www.harlemsolicitors.com or follow us on our social media pages at HARLEM Solicitors via LinkedIn, Facebook, Instagram. Thank you.